Good morning, this is your Kelso Report for Tuesday, January 24th, and I'm your host, Clark Kelso. In our hyper-connected world, privacy is rapidly becoming a thing of the past. But for our Supreme Court, advances in technology don't always come at the expense of our constitutional rights under the Fourth Amendment. Justice Scalia in particular has been wary about letting technology advances shrink reasonable expectations of privacy. And he does it again in the court's decision in United States v. Jones, where a unanimous court held that the government's attachment of a global positioning system device to a vehicle for purposes of tracking the vehicle's movements constitutes a search under the Fourth Amendment, and is therefore subject to the Fourth Amendment's warrant requirement. Now, consistent with his textualist philosophy, Scalia notes that the Fourth Amendment expressly protects, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, close quote. Well, he argues that a car constitutes an effect under this language, and that attaching a tracking device to an effect would have constituted a search within the meaning of the Fourth Amendment at the time it was adopted. Now, there are several concurring opinions, and thus some differences in reasoning and emphasis, but all of the justices concurred in the result. Next, we turn to an issue under criminal law. The Federal Sex Offender Registration and Notification Act requires convicted sex offenders to provide state government with information such as names and current addresses for state and federal sex offender registries, and to update that information as appropriate. Although the Act defined sex offender to include offenders convicted prior to the Act's effective date, it also provided that, quote, the Attorney General shall have the authority to specify the applicability of the registration requirements, close quote, to pre-Act offenders. Well, in Reynolds v. United States, the United States Supreme Court faced a case where the defendant had argued that vesting the power to determine the retroactive application of the Act to pre-Act offenders violated the non-delegation doctrine. Now, the Third Circuit had avoided this constitutional issue by interpreting the Act as applying to pre-Act offenders irrespective of what the Attorney General did. Well, in yesterday's decision, the Supreme Court reversed by a 7-2 vote, holding that the plain language of the Act gave the Attorney General the power to determine whether and how to apply the Registration Act's requirements to offenders convicted prior to enactment of the Act. So, the court then remanded to the Third District to consider the merits of the non-delegation argument. Next, an important case involving food and agriculture regulation. The Federal Meat Inspection Act regulates a broad range of practices at slaughterhouses to ensure the safety of the meat and the humane handling of animals. Federal regulations specify the steps to be taken with respect to non-ambulatory and diseased animals. 3 years ago, in response to a widely viewed videotape, California amended its penal code to provide that no slaughterhouse could, quote, buy, sell, or receive a non-ambulatory animal, close quote, process, butcher, or sell meat or products of non-ambulatory animals for human consumption, or hold a non-ambulatory animal without taking immediate action to humanely euthanize the animal, close quote. Now, in National Meat Association v. Harris, the Supreme Court unanimously held that the Federal Act preempted California's law. The Federal Act contained a broad preemption clause precluding states from imposing requirements that are, quote, within the scope, close quote, of the Federal Act, or relate to slaughterhouse, quote, premises, facilities, and operations, and are in addition to or different than those made under the Federal Act. This broad preemption clause was enough to sweep away California's attempt to regulate the same activities and subject matter. Next, an issue involving qualified immunity of city police officers. Now, as a general matter, the Supreme Court, as you know, only takes cases to deal with novel or unsettled questions of law. Every now and then, the court will take a case just to correct a mistaken decision by the lower courts. And you can often tell when that happens because the result is unanimous and declared in a per curiam opinion. That appears to be what happened in Ryburn versus Huff, where the court reversed a Ninth Circuit decision that had denied qualified immunity to two officers who had followed a mother into her home when, in response to a question about whether she had any guns in the home, she turned and ran into the home. The officers were at the house to investigate concerns that her son may have threatened to shoot students at his high school. So the officers followed her in. They remained in the home only 5 to 10 minutes, did not conduct a search, and did not detain the mother or son. And once they had this opportunity to talk to the parents and child, they realized the school concerns were unfounded, and they left. The parents sued for damages under Section 1983. Now, there was no new law here in this opinion. The district court held that the officers were entitled to qualified immunity because the mother's odd behavior, combined with the information gathered at the school, could have led reasonable officers to believe that there could be weapons inside the house and that family members of the officers themselves were in danger. The Ninth Circuit reversed, concluding that the officers' belief that they might be threatened was objectively unreasonable by a 2-to-1 vote. The Supreme Court granted review and reversed in its per curiam opinion yesterday. In reversing, the court explained that the Ninth Circuit should have viewed all of the facts together instead of analyzing each individual step separately, and that it should be cautious about second-guessing a police officer's assessment on the scene about the danger presented by a particular situation. Now we turn to a Ninth Circuit decision involving the area of employment law and proper interpretation of ERISA, the Employee Retirement Act. In recent years, the Supreme Court has been trying to help lower courts retreat from prior holdings that various statutory requirements are jurisdictional requirements. Under the Court's recent cases, a statutory requirement is jurisdictional really only if Congress has clearly indicated that it intends the statutory limitation to be jurisdictional. So it was in Leeson versus Transamerica Disability that the Ninth Circuit overruled its 1995 holding in Curtis versus Nevada Bonding that a district court lacked jurisdiction to consider an ERISA claim where a former employee had neither a reasonable expectation of returning to employment or a colorable claim to vested benefits. In Leeson, the court overruled Curtis and held that the question of whether the plaintiff, a former employee, was a plan participant with standing to sue was not a jurisdictional question, but instead went to the merits of the plaintiff's cause of action. The Ninth Circuit remanded so the district court could reach the merits of the plaintiff's claims. Next, we have two opinions from the California Supreme Court. The first involving an issue involving appellate procedure. Now, it's an exquisitely technical holding in this case. The Supreme Court of California unanimously held in Rasa versus D.L. Falk Construction that California Rule of Court 8.278 D1F, which provides that a party may recover as costs to a successful appeal, quote, the cost to procure a surety bond, including the premium and the cost to obtain a letter of credit as collateral, close quote. The court held that that language does not include the interest expenses incurred in borrowing money to obtain the letter of credit. Now, as you know, there are fees that must be paid to obtain a letter of credit, and those are within the scope of the rule. But the fact that the appellant had to borrow to obtain the letter of credit and incurred additional interest charges as part of that borrowing was too far removed from the rule. In this case, the appellant had to obtain $1 million bond, and the interest expenses associated with borrowing to obtain the letter of credit was $100,000. So although the holding is very narrow and this is technical, it clearly was definitely worth litigating. The court also had a criminal law decision in the case of People v. Mill, where the defendant was convicted of first-degree murder, and the jury made true findings as to the burglary murder and robbery murder special circumstances. The jury had been fully instructed on felony murder special circumstances for a defendant who was the actual killer, but had not been fully instructed for a defendant who was not the actual killer. This meant the jury was not instructed that if the defendant was not the actual killer, absent a showing of intent to kill, he must have acted with reckless indifference to human life and as a major participant in the commission of the underlying felony. The Court of Appeals had recognized the instructional error, but held it was harmless. Reversing, the Supreme Court of California held that this instructional error was indeed prejudicial, and have therefore reversed the special circumstances finding and remanded for further proceedings. And our last case today is the California Court of Appeal in the area of employment law. In a retaliatory termination case, the final result often comes down to credibility and inferences to be drawn from circumstantial evidence. To help trial courts work through the issues in these cases, the law has developed various burden-shifting rules. Under these rules, if the plaintiff establishes a prima facie case of retaliatory discharge, the burden of production shifts to the employer to come forward with a legitimate reason for the termination. And if the employer does that, the burden shifts back to the plaintiff to come forward with evidence of intentional retaliation. In Joaquin v. City of Los Angeles, the 2nd District held that the plaintiff, a police department officer, ultimately failed to present substantial evidence of the city's intent to discharge him in retaliation for his having brought a sexual harassment charge against another member of the police force. The department had investigated that prior charge and determined that it was fabricated. The plaintiff was then discharged because of his fabricated charge of sexual harassment, and not in retaliation for his simply having brought a harassment allegation. As the court noted, quote, "In appropriate circumstances, an employer may discipline or terminate an employee for making false charges, even where the subject matter of those charges is an allegation of sexual harassment." Close quote. And that's it for today's Kelso Report. Have a great day in the law.